please. Just go ahead.
So there's a war on labor in the United States today. There's a war on working people. Unfortunately, the only people that have been paying attention to that war over the past decade or so are unions. And we recently saw more participation from folks in Wisconsin, the bills in Idaho, the bill in Ohio, different pieces of legislation that are coming forward to, in essence, deepen that war on labor. There's work that's been started over the past 15 years in places like Pennsylvania, and on its face it may seem different than the issues facing labor at this point in time, but communities in Pennsylvania and Maine and New Hampshire, communities in California, Virginia, different places across the United States have begun taking the law into their own hands with the recognition that not only is there a war on labor, but there's a war on communities. And so communities trying to stop, for example, big box stores from coming into their locality, or agribusiness factory farms, these 15,000 head hog factory farms sprouting up across the United States, in addition to natural gas extraction, those types of things across the country, that communities are coming to the conclusion that they don't run their own community, but corporations do, and corporate decision makers. And so starting back in 1999, these communities began adopting local laws. And we tend to look at those local laws as a new civil rights movement happening in the United States, which in essence are codifying or putting rights for the community into local ordinance structures. And it's that rights-based framework that came to Spokane back in 2007 when representatives from labor unions came together with environmental organizations, came together with neighborhood associations to say to themselves, hey, you know, the situation that these folks back east and someplace on the West Coast are facing is the same issues we're facing today, which is in essence that our neighborhoods don't have rights against corporate developers. Our ecosystems like the Spokane River don't have rights against corporate polluters. And perhaps more importantly than those issues is that working people don't have rights against their employers. That may sound funny somewhat, but the truth is that under today's structure of law, when we walk into the corporate workplace, we lose or are stripped of all of our constitutional rights and protections. So for example, we don't have free speech rights in the workplace. Our First Amendment rights are stripped from us. We don't have a right against search and seizure because our Fourth Amendment rights are stripped from us. We don't have due process rights in the workplace, which means if we're in a non-unionized workplace, that we can be fired at will, that there's no protections for our due process rights in the workplace. And so what this means to us is that things like captive audience meetings, which would normally violate our First Amendment rights, continue on unabated and are used in over 90% of unionization efforts by employers to intervene and try to stop that unionization from happening in the workplace because we don't have First Amendment rights in the workplace. Fourth Amendment rights, we can have our vehicles searched, our lockers searched. We have no Fourth Amendment rights in the workplace, and those types of things can happen where we work. Due process protections, once again, non-unionized workplaces, workers don't have those protections in the workplace. But in essence, we have a structure of law that, by default, has systematically stripped us of rights as workers in the workplace, and so subjects us to a variety of those different violations, or what normally would be considered violations in the workplace. The difference between this work and the work that normally happens with environmental groups or neighborhood groups or labor unions is that it's beginning to understand that to secure these rights for ourselves, we actually have to seize the structure of law to drive those rights in. And in Spokane in 2009, a unique coalition of labor unions, neighborhood associations, environmental groups, community organizations came together to propose something called Proposition 4, also known as a Community Bill of Rights. And that Community Bill of Rights actually dealt with issues like captive audience meetings in the workplace and efforts by employers to interfere with unionization. In effect, attempting to drive a new Bill of Rights for workers, a workers' Bill of Rights, into the city charter for the city of Spokane. Now, Proposition 4 failed at the polling place, and it wasn't unpredictable that it would when the opposition raises over $400,000 and is the corporate opposition, the Chamber of Commerce, and folks that don't want to see these types of things move. Proposition 4 is now back in the form of a new initiative, a new Community Bill of Rights, And this new Community Bill of Rights is also a Bill of Rights for labor. Specifically, it actually mandates that collective bargaining be one of those things that unions possess within the city of Spokane. This war on labor that's occurred across the United States, in Wisconsin, for example, is about stripping away collective bargaining rights from public unions. The folks in Spokane running this new initiative in 2011 felt that it was very important to include collective bargaining in this new Labor Bill of Rights. And so it mandates that organized workplaces within the city of Spokane, public or private, because this war on labor is eventually going to expand, and has been expanding beyond the public workplaces, to private unions, that this effort in Spokane is about guaranteeing that organized workplaces have access to collective bargaining. And so that's a big piece of the Labor Bill of Rights within this new Community Bill of Rights initiative. In addition to that, it restores First Amendment rights to free speech within the workplace, would guarantee Fourth Amendment rights against unreasonable searches and seizures in the workplace. And in addition, for those non-unionized workplaces, would also guarantee due process rights, which would guarantee against things like being fired at will. Under these at-will arrangements for workplaces in the city of Spokane. It's a labor bill of rights, it's a community bill of rights, it's a bill of rights that's being driven locally into the city charter of Spokane, with the understanding that these efforts, whether they're in Spokane or Yakima or Bellingham or Seattle or places across Washington State or in fact across the United States, are eventually going to stitch together to do something that is perhaps much more groundbreaking, which is to change the state constitution, to actually drive this Labor Bill of Rights into the state constitution and probably eventually into the federal constitution. It's about going on the offensive instead of being stuck on the defensive and trying to fight to continue and maintain and defend what we have. It's about going on the offensive to begin driving these rights directly into the constitutional structure, to begin here in the city of Spokane. And that's why we're asking folks in the labor community who were primary supporters of the Community Bill of Rights back in 2009 to not only support the Bill of Rights, to gather petition signatures to qualify this initiative by July of 2011 for the city of Spokane, and to turn members out to vote for it, because this Bill of Rights, collectively between neighborhoods, community organizations, and labor, is setting the standard. It's the first place in Washington State that this is happening. It's spreading to other places in Washington State and beyond, and this is the new initiative to drive a new civil rights movement, a new Labor Bill of Rights into the city charter, which eventually will have echoes further up into higher levels of government.
Okay.
So we've talked about the Labor Bill of Rights piece, which is a huge part of the Community Bill of Rights. There are three other sections to the Community Bill of Rights. The first one deals with a neighborhood control over rezonings that are being done for development in the communities. And basically this is the concept that whereas we treat neighborhoods as having some kind of authority under the city charter of Spokane at this point, they really don't. And so when a corporate developer comes in, let's say a Walmart or a big box store, and comes into an area of a neighborhood that's zoned specifically for residential, that currently today in the search for tax revenue, generally the city council grants those rezoning requests for those large corporate megastores to come in. This would actually give the neighborhood authority to say yes or no to a rezoning that occurs. So once again, if a rezoning request comes in from like a corporate megastore, a big box store, that the neighborhood actually has the authority to say yes or no to that rezoning that's requested by that megastore. It's not about stopping development, it's just about the fact that the law is the law. And the law at this point is the zoning ordinance that's in place. And there's a lot of hinky stuff that goes on with developers coming in and asking for rezonings through these requests and then being granted them without any consideration whatsoever of the quality of life for the neighborhood or other aspects of what neighborhoods want to see in terms of their community. And so this gives a check on the city council. It's a check and balance of some sort, whereas the neighborhood has the power to say yes or no to that rezoning that's being requested by that corporate developer coming in to develop the community. In addition to that first plank about what we call the Neighborhood Bill of Rights provision, giving neighborhoods authority to make those decisions about rezoning, In addition to that, there are provisions, the second part of the Community Bill of Rights deals with the Spokane River and the Spokane Aquifer. There's a lot of feeling in the city of Spokane that the Spokane River and aquifer need to be better protected. Under the existing structure of law, they're provided minimal protections, and essentially you have corporations sitting around a table deciding, for example, what the water flow is going to be for the Spokane River and how often the dams are going to be closed and the hydroelectric is going to run, or what kind of pollutants can be emitted, total daily load into the rivers. In other words, how much can we pollute them before we begin to affect their functioning. This second provision would actually provide more protections for the Spokane River and the aquifer, allowing people to step in and protect those resources when those resources are threatened by that type of pollution or control. And finally, in addition to the Labor Bill of Rights piece, which is the third provision of the Community Bill of Rights, there's a fourth provision. And the fourth provision is also a little controversial, but it deals with corporations and corporate rights. In essence, we could march down this list of rights. In other words, what the Community Bill of Rights does is create rights. It recognizes certain rights on behalf of neighborhoods, on behalf of nature, and on behalf of labor. But if we stop there, just with the creation of those rights, it's very clear that under our existing system of law, that corporations and corporate decision makers are allotted more rights, greater rights, than people in communities. So if we created those rights, they're not necessarily enforceable against those corporations unless we take an additional step. And that additional step is to make sure that corporations don't have more rights than the rights that are outlined in the Community Bill of Rights. It, in essence, makes the Labor Bill of Rights and the Neighborhood Bill of Rights enforceable against corporations, who, once again, under the system of law, seem to have more rights than our communities do themselves. This is about righting that balance. It's about giving the upper hand to rights that are codified within the Community Bill of Rights so that they're not subordinated or nullified by those corporate rights. Now, this is an issue that's gotten a lot of national attention, just like the collective bargaining provision in the Labor Bill of Rights section of the initiative. And what's gotten a lot of press about corporate rights is things like Citizens United, this U.S. Supreme Court case, which declared that corporations were persons under the law and therefore could spend as much as they wanted in federal elections. This provision actually is an open challenge to that law that's been established by the Supreme Court. It's an understanding that we can't just beg and plead the courts or beg and plead Congress to change this for us, that we need to actually begin to refuse to recognize that corporations have more rights in our communities, and then begin to right that balance at the local level. And once again, joining with other communities across the state of Washington, folks doing this work, starting to do this work in Idaho, in Montana, and California, and different localities, beginning to push up, an effort to push this stuff up to the state and federal level, so that once and for all, our community rights at the community level, whether it's labor rights, whether it's neighborhood rights, whether it's rights for nature and the river and other things that we hold dear within the city of Spokane, that those rights and values are actually superior to the rights and values of corporate decision makers, sometimes coming in from 3,000 miles away to tell us what to do in our own community and to establish that corporate vision for our community over the next 20, 40, or 60 years, rather than a vision for our community that deals with labor rights, community rights, and neighborhood rights.
Good.